Jeff Glasner is here with Boughton Law. Boughton Law is CKNW's on-air legal analyst for 2015. Jeff, thanks for being in studio with us.
Thanks for having me, Jill.
I think a lot of people, it's not something you talk about too much when you're at parties and such, but a lot of people might be in that situation where they haven't paid, they're not sure what they paid and what to do.
You would be surprised. There are a lot of people in that situation, just judging by the volume of calls I get, cold calls on the subject. And one of the things I generally tell people after they've told me their situation is, you're in good company and you're doing the right thing. You're trying to take care of it, and we can help you through it.
What is it, do you think, that prompts people to find, if they're in that situation, that prompts people? Is it a letter from the CRA, or what is it that prompts them to take action and think, okay, I can't be in this situation anymore?
Often it's a letter. They'll get that brown envelope in the mail. They may be getting phone calls from a collections officer, or they may see that the CRA has already started taking action against them, which means they've probably disregarded previous attempts at communication from the CRA, or perhaps it's as simple as them having moved and not updated their address and letters going to the wrong place.
What are the consequences of not paying your bill?
The CRA has some strong collection powers. For example, they can, once a bill is collectible, they can go ahead and freeze your bank accounts. So you may get advance notice of this from your banker, or you may see that a check has bounced to your landlord, to your employee, and suddenly there's that embarrassment, and you go back to the bank to try to figure out what happened. You thought you had the money in your account, and what you find out is that the CRA has sent them what's called a requirement to pay, and they have both emptied and frozen your bank account.
Yikes, that would not be a good day to come home to that.
It's not. If it's a personal bank account, that's one thing. That's bad enough. But if it's a business bank account, that can cause you some major problems.
Is there a certain amount that would trigger the CRA to do that, or is it anybody that owes money?
That's one of the, what I would call, the easier powers for them to act on. So, while I would be surprised if they would take those steps on a $50 amount owing, they could. What we often see is, in the $2,000-$3,000 range. Certainly, that's not too low for them to take that action.
All right. And what else can they do? What else should we be
One other thing they certainly can do is garnish your salary if you're an employee somewhere. So in that situation, the baseline, generally, it's going to be about 30% of your salary. And I get these calls all the time, aside from the financial stress of suddenly having 30% taken off your paycheck, there's that embarrassment of knowing, now your employer knows. Mm-hmm. What are they going to do about that? Who are they going to tell? So it puts people in a difficult situation.
And what about if you have assets?
There's the power to seize and sell assets. They can send the bailiff in. I've seen situations where there's a high-end restaurant bar, and the bailiff's there taking inventory without notice of all the high-end liquor and putting it in boxes, and I'm forced on the other line to be communicating with and negotiating with the collections officer to try to call the bailiff off. So these things happen without warning and can interfere with business.
Exactly. So moving on from that, or are there any other ways that we should be?
There's a couple other common ones, very similar to garnishing your salary. They can intercept receivables. So if you're in business and you have some customers who owe you money, the CRA can require you to provide that list, and they can go and intercept the full amount of those payments to you. So just like the situation where your salary is garnished from your employer, in this situation, not only there's the financial stress of not getting any of the money, it's 100% usually in this case, but you have your customers, your clients, they know that you have this issue, and that can cause some serious harm to your business. The other common one I would talk about is liens. If you have a house in your name, the CRA may come in and put a lien against your property in their favor. What this means practically usually is, if you're going to sell that property, the CRA is going to get paid out just like they're a mortgage holder. But in today's environment in the Lower Mainland with the rising house prices, a lot of people there are trying to refinance to take advantage of their increased equity. This can cause a serious problem when you're trying to refinance.
Yeah, you don't want the lien on your house when you're going to the bank for that.
Best to be avoided, yeah.
Could they put a lien on your vehicle as well?
They can, that would be something the bailiff could do, come in and take your vehicle. Yep.
All right. Third parties. What about if other people are involved? You mentioned, it can be embarrassing if your employer finds out because your salary is being taken and that. What about third party or family members and that are involved?
Right. Family members is something we're seeing more and more of. There's a provision in the Income Tax Act which allows the CRA to go after a tax debtor's family members if the tax debtor has transferred assets to them, which the family member didn't pay for. So, this could be putting the husband putting the house in wife's name, or wife or mother tax debtor paying for the university tuition of her children, or a husband taking cash out of his bank account and giving it to the wife or his siblings. The CRA then will go after these third parties who probably have assets that the CRA can come after. It doesn't have to be the same assets that were transferred to them. And they will try to recover at least the amount that was transferred to them, minus anything that was paid or owed to them for it.
Because isn't that something that people might do if you have a tax bill that you can't pay, or you're in this situation? Don't people try to put it over to a spouse or somebody as a way of trying to hide it? Or,
certainly, and that's certainly the intention of the provision. There's no criticism of the government of putting in that section of the Income Tax Act, and that's what it's meant to catch. But it catches other things. There doesn't have to be any intention there. The transferor may not even know they have a tax debt. The transferee may not know of the tax debt. It could be as simple as father paying for a daughter's wedding. So daughter doesn't have that asset. That money is spent, but now the CRA is coming after her. So there's a lot of innocent or more innocent sounding situations that get captured by this.
In that case, though, that's an interesting one because the money's gone. The money has been spent. So what is the CRA actually going after?
CRA can go after any other assets there. So it's not a tracing mechanism. It's not going after the actual asset that was transferred. It's just now making a second person also responsible for the first person's debt. And then they can go through that whole list of powers that I went through before, garnishing their paycheck, putting liens against their homes that they could have with the first party.
Yikes. Do you think people understand that if they're doing that and thinking that they're outsmarting the CRA or they've figured out this way to try and get around it? Do people know that, wait a minute, no, the CRA is actually probably a step ahead of you and has more power than you might know?
I can only judge by the volume of calls and people who come in who have found themselves in this situation, has seen the CRA, and the CRA has seen it and sent the letter. And by that, it's my opinion that a lot of people aren't aware of this particular CRA power.
Yikes. All right, Jeff, we're going to take a short break. My guest is Jeff Glasner. He's a lawyer with Boughton Law. A reminder that this discussion does not constitute legal advice, but we will continue talking about what you need to know if you can't pay your tax bill in full or on time to the CRA. We'll continue with Jeff Glasner when we come back. Thanks for being with us today. My guest is Jeff Glasner. He is a lawyer with Boughton Law. We are talking today about what happens when you can't pay your tax bill in full and or on time. And just a reminder that this is not legal advice. We are talking about, though, if you are in that situation. And Jeff, before the break, we were talking about third parties being held responsible. And I think that's an interesting one because I think, as we mentioned, not everybody understands that trying to hide things from the CRA and transferring things, they do have ways to come and get. If they want the money that they are owed, they have ways to come and get it.
Yep, those powers are there, and they're taken advantage of. We see it more and more. Maybe it's a sign of the economy that CRA is forced to or chooses to go after third parties now more so for first parties' debt. But the power's there, and of course there's defenses to all of these attempts by them that may apply, and that's why it's a good idea to speak with the tax lawyer about these situations.
Talk about going after the directors of corporations for GST and payroll.
Sure, certainly. So, a lot of people are aware of the fact that a corporation is like or is a separate legal entity. So one may think that a corporation's debt is its debt and an individual's debt is their debt. And that's generally true unless there's a legislative reason, a law that allows the CRA to go after the individual for the corporation's debt. One of those situations is director's liability. And when we speak director's liability, we're not talking about income tax debts of the corporation, but we are talking about things like GST and things like employee remittances. So the CRA can come after a director, an actual director, someone showing on the corporate search as being a director, for these sorts of liabilities that arose during their watch. They can come after them for a period of up to 2 years from the time they last ceased to be a director. So if they resign and they resign properly, 2 years later, CRA cannot go after them anymore. The issue gets a bit more complicated because the CRA does not only have the ability to go after what they call de jure directors, which are those that are listed, but also de facto directors. So people who act like directors. They may have never signed the form. They may have never had their name put in the corporate registry. But if they're portraying themselves as directors or doing director-type activities, the CRA can come after them for the GST and payroll liabilities of the corporation.
Wouldn't there be some room for interpretation there if the CRA is saying, well, you've acted like a director, and somebody's saying, no, not really. I don't consider myself a director. It's not my title.
Right. And then that's one of the things that a tax lawyer will help you with making that argument for you. Generally, CRA collections are going to be very aggressive on these matters. And in this situation in particular, what is acting like a director? When are you a de facto director? It actually seems to be a pretty low threshold these days, at least as dictated by the tax court. So you can have situations, I've seen this, where someone who used to be a director, their 2-year clock has run out a long time ago, they've got nothing to do with the corporation anymore, they get a call out of the blue from the CRA, and the CRA says, listen, we just need your help trying to collect this debt. Do you know the name or address of so-and-so who may still be a director? Or do you have any boxes of records from around that time that you can help us with? And often, or at least in many situations, a natural response is, listen, in your mind, you want to help out, you want to be the good citizen, and you may answer those questions thinking there's no way they can come after me anymore. I'm just helping the CRA do their job. But that action of helping them, or delivering the boxes or providing information, that action in itself has been held to be enough to show that you're a de facto director. So what that would do is, as soon as you take that action, the CRA would say, well, your 2-year clock has restarted. We are coming after you now.
Doesn't that send the message if the CRA asks for your help, best not to give it?
Well, that's one way to put it, but that's the reality sometimes. So that's one of the reasons you may want to talk to a tax lawyer or someone else who can look at the situation with you and let you know exactly, if you do want to help, what you can say, what liability that might expose you to. And you may want to use an intermediary, like the lawyer, to provide this advice to them.
And is this something more, you think, for smaller businesses, whereas in bigger companies, it seems to be a bit more clear who's the director and what titles people have, whereas in smaller businesses, there's probably more crossover?
Yeah, certainly, because people wear many hats in a small business. You may be the shareholder, the manager, the supervisor, the main employee, and the director. So maybe you've taken off that director hat, maybe someone else has put it on, and maybe it's been a couple of years, but you're still involved with the corporation in that situation. You're the guy behind the desk. You're the person going to the bank and doing the deposits. Things like that may look like you're a de facto director, and the CRA may seize upon those things to attempt to assess you under director's liability.
All right. We will continue talking about this. We'll touch on how you can pay if you owe money, tips for dealing with the CRA. My guest is Jeff Glazner with Boughton Law. We will continue when we come back. I'm with Jeff Glazner. He's a lawyer at Boughton Law. We are talking about what to do when you can't pay your tax bill in full or if you can't pay it on time. And Jeff, you talked about some of the things the CRA can do if you owe them money. What about payments? Because I think there's that general idea that if you can't pay it in full, we're entitled to a payment plan, but it sounds like that's not exactly the case.
Yeah, that's not. There's nowhere that says you are entitled to the payment plan, but it is something that happens often. You just have to go through certain steps. So the CRA does have the discretion, of course, to offer you a payment plan. What they're going to want if you approach them for this, or generally it's them approaching you for payment in full and you're responding with, listen, this is what I can afford a month, is they're going to want you to make full disclosure of your assets, of your liabilities, of your income, and of your expenses, just to see that what you are proposing to give them is reasonable. They're also going to want you to try to exhaust all your ability to borrow from family, to borrow from the bank and such. They may ask to see a rejection letter from the bank to show that you cannot borrow these funds up front and to show that the only way that they can recover is by getting these monthly amounts from you.
All right. And what are some of your tips for if you're in the situation and just dealing day-to-day dealings with the CRA?
Well, you've got to watch. You've got to watch that you haven't exposed any family members, for one. You've got to watch that there is the ability there to live up to the payment plan that you propose to them, because you can get yourself in more trouble if you say I can pay $3,500 a month, and then by the third month you're already bouncing checks. It's very difficult to recover from that and to say, oh, that was a one-time thing. That may cause them to escalate their collection powers against you.
And I would imagine that ignoring them is not going to make the problem go away.
Yeah, no, it's amazing how many times I have people say, listen, I have this pile of brown envelopes. I haven't opened them because I didn't want to deal with it. Whatever it is from the CRA, there's generally timelines attached to it. And there's a lot that can be done if things are caught in time. If you can see a professional to talk about it, if they've assessed you for an amount that isn't correct, you have 90 days to object. If they don't accept your objection, you have 90 days to appeal that further. So there's these time limits, there's these generous time limits set out for you. But if you don't open the envelope, then you can find yourself in a lot of trouble.
Exactly. All right, what can people do if they have more questions, they want more information about this?
Well, certainly they can give me a call. We get these calls all the time. My direct line is 604-647-5527. And, before you make that decision about whether you're going to hire a lawyer or not, you should have that discussion with the lawyer and see whether it's something they think they can help you with. So we get those calls all the time, and we're happy to be an ear and open ear for them and to lend them some advice ahead of that decision.
All right. Jeff, thank you so much. That is Jeff Glazner. He's a lawyer with Boughton Law. Boughton Law is CKNW's on-air legal analyst for 2015.